there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dark pass away, get the sound of a shotgun shell.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be bound.
Neighbors hide behind their blinds, whisper tales of troubled minds. Skeletons covering the mountainside, a treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't mask their cries. Shadows caught in sunlit skies. There's no cover, no disguise. All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be
Winter reveals the hidden lie. Moonlight could mask their cries. Shadows caught in sunlit skies. There's no cover, no disguise.
all the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be bound.
Hey, welcome back. If you weren't with us in the first video that we just got off, welcome to the show. This is Hillbilly Crime, and my name's Elizabeth. Sweet Tater is not going to be on tonight. She's already in bed. Kind of figured whenever she didn't join the last one. Too late for her. All right, guys, breaking news. Mickey makes motion for dismissal and bond. So much corruption. Thank you for your super sticker. Thank you. All right. Yes, so big news today. Let me go ahead and exit out of that stuff. Now, I'm just going to read the motions. We've got 2 motions. I'll read to you guys what the Mountain Eagle put out, but we got a whole lot more than the Mountain Eagle put out. So, that's exciting. That's exciting. Okay. So all they put out was kind of a little summary, and then they said that more will be in the next week's paper. But they put this out today on the Facebook. Defense wants charge against Stines dismissed. Somebody sent me a message right before we came on here, and she said, my jaw hit the floor. I read it. I'm still sitting here with my mouth open. Well, wait till you find out why they're asking for a dismissal. Crazy. Jeremy Bartley, you guys. He's a good lawyer. All right. Defense wants charge against Stines dismissed. Defense attorneys for former Sheriff Sean Mickey Stines have filed a motion asking for the Red Rum indictment against him to be dismissed. The motion is one of two filed in the case today. So these were just filed today. The other asks that bond be set at an amount that will allow Stines to meet that bond and return home. In the motion to dismiss the indictment, the defense attorneys Jeremy and Carrie Bartley and James Cox argue that there was another meeting between Special Prosecutor Jackie Steele and the grand jury before the murder indictment was returned, and that the meeting was not recorded. Whose job is that to make sure that their grand jury meeting is recorded? Whose job is that? I mean, I thought it was the circuit court clerk's job. Would that be Mike Watts? I like Mike Watts Sr., buddy. He was the only one that helped me. And another lady that I talked to today about her situation, she said the same thing. She said Mike Watts had helped her, and I said, junior or senior? And she said, senior. I said, honey, that's who helped me too. But whose job is that to make sure that that's recorded? Would that be, I don't know. Would that be the person in the prosecutor's office who actually coordinates the grand jury? Would it be the judge? I don't know. Whose job is it to make sure that their grand jury meeting was recorded? And Jackie Steele is pushing back. He's pushing back against it. All right. That the meeting was not recorded. The law requires grand jury testimony to be recorded, but the prosecution has said that there was no testimony at the first meeting, only a request for grand jury subpoenas for witnesses. The defense claims in the motion that grand jurors in the recorded session asked about a civil case in which Stines was a defendant in his official capacity, the one that they just replaced him in, but were redirected to deprive the grand jury of its independent investigation. So that means, now listen, I'm no lawyer, but what I do know about the justice system is that a grand jury can investigate anything they want to. A grand jury has the ability and they have the power to send out subpoenas on anything. Like they can investigate the prosecutor himself if they wanted to. So I don't know. We're going to read the whole motion though. I'm just reading you what the Eagle said. They were redirected to deprive the grand jury of its independent investigation. The attorneys are seeking for an evidentiary hearing and dismissal of the indictment. The Commonwealth has not yet filed a response to the motion. In the second motion filed today, the defense asks that Stines be granted a bond hearing following the psychiatric examination scheduled for later this month. They say Stines is entitled to bond because the indictment alone contains no proof that guilt is evident or the presumption of guilt is great. Special Lecture Circuit Judge Christopher Cohen, who presides over court in the 8th Circuit in Warren County, which is all the way on the entirely other end of the state. That's on the western side. It's like Bowling Green or somewhere where he's from. He has indicated he will travel to Letcher County for any bond hearing held in this case. Stines is charged with murdering Letcher District Judge Kevin R. Mullins in his chambers on September 19th, 2024. The shooting was captured on a security camera in Mullins' office. We will have more information in next week's edition of the Mountain Eagle. Well, we're going to go ahead and read it tonight. I'm not going to put it on the screen though. I'm just going to read it. All right. So, the Commonwealth of Kentucky versus Sean Mickey Stines. Motion for bond hearing. Let me take that off of there too. Thank you, honey. Thank you. Thank you. And Miss Tammy, thank you. Thank you. Bless you. Bless you. Bless you. Okay. All right. Motion for bond hearing. I'm just going to skip through all the boring legal stuff. On November 21st, 2024, the Letcher County Grand Jury returned an indictment against Mr. Stines, charging him with 1 count of aggravated red rum. No bond was set. On November 25th, 2024, Mr. Stines was arraigned, and then presiding Judge Adams declined to set a bond, leaving same for the special judge yet to be assigned. As of June 2025, a bond has not been set. Mr. Stines has given notice of his intent to introduce a mental health defense at trial. Mr. Stines was ordered to undergo a mental health evaluation by KCPC. Same is set for June 2025. So several people thought that his mental evaluation had already happened, that it had already taken place. Nope, it has not taken place. It doesn't look like it's going to until this month. All right. The word bailable in Kentucky Constitution has been interpreted to mean that, at least initially, all prisoners are entitled to bail. The right to bail is a constitutional right guaranteed to every prisoner as defined in that section of the Constitution. At the time of the indictment and prior to the entry of any proof, all prisoners who request bail, including those charged with capital offenses, are entitled to bail. Now, this is a Kentucky statute. Okay. This entitlement is based on the presumption of innocence and the practical reality that the indictment alone contains no proof that guilt is evident or the presumption of guilt is great. The indictment does not furnish proof of his guilt that is evident, and in fact, it furnishes no proof of his guilt upon which the circuit court may act in allowing or denying bail. Neither does the indictment create a presumption of guilt, which is great. To overcome the presumption of innocence and the lack of proof in the indictment, the Commonwealth then has the opportunity to demonstrate that proof of guilt is evident or the presumption of guilt is great. The trial court is vested with sound discretion in considering whether the Commonwealth has met this burden. if the court determines that bail is available. KRS 431.525 mandates that it must consider the following in setting an appropriate bail. Bail is sufficient to ensure compliance with the conditions of release set by the court. That was number one. Number two, bail is not oppressive. Number three, bail is commensurate with the natural or with the nature of the offense charged. So I guess they're saying bail is, appropriate, I guess would be another word for the nature of the offense. Bail is considerate of the past criminal acts of the defendant, which he was a sheriff and had absolutely zero criminal history, so that he doesn't have any of that kind of stuff hanging over his head. And bail, number five, bail is considerate of the reasonably anticipated conduct of the defendant if released. And number six, bail is considerate of the financial ability of the defendant. The defendant in this case is charged with a single count of aggravated murder. Prior to his arrest, Mr. Stines had Mr. Stines had an exemplary record with a complete lack of criminality or deviance. Mr. Stines has served in a law enforcement capacity for his entire adult life and was actively serving as sheriff of Letcher County, Kentucky, when he was arrested. Upon his arrest, pretrial services completed a risk assessment, scoring Mr. Stines as an FTA risk low, 0, and an NCA risk low, 0. So they pretty much are saying that there's no risk of him reoffending if he does get out. I'm not really sure what I think about that. What do you guys think about that? Do you think that he would be at risk of reoffending? I don't know how to answer that. I don't really know how to answer that. All right. Mr. Stines has been a lifelong resident of Letcher County, Kentucky. He has a wife, children, grandchildren, and a host of friends who remain staunchly supportive of him. Considering Mr. Stines' strong ties to the community, lack of criminal record, and family support, it is apparent that Mr. Stines would be compliant with any conditions set by this court. Wherefore, the defendant respectfully requests that this honorable court set an adversarial bond hearing at the court's convenience, but following completion of the KCPC evaluation scheduled for June 2025. And then it was just signed by everybody. Okay. Now, that was the short one. Now we're going to read the dismissal motion. Oh my gosh. I knew that they would be requesting a bail eventually. That's kind of usually what they do. when you have a defendant who's charged with such a serious crime, they will leave them in jail for a little while and give them some time under their belt, so to speak. And then the lawyer will bring it a motion for bond in front of the court. And they don't want to bring those motions too soon because they'll just get denied, which this is kind of a different kind of case, though, you know. There's a ton of free Mickeys in here tonight, y'all. There for a while, I was starting to wonder if there we go. I know that the tide has changed in public support, like people speaking about it publicly. I cannot tell you how scared people are. Like, people are afraid to talk about other cases. People are afraid, and they're not so much afraid for themselves as much as they are for like their family members and their children. You know, their kids live here. Even if they're grown kids, they still have kids here. They still have grandchildren that go to school here. They have kids who play on ball teams. And in certain, I won't say no names, but in certain schools or whatever, you kind of have a hierarchy, you know, that politics and who your daddy is kind of thing really, really matters in some schools, and in others, not so much. And so people worry about that, you know, is my kid going to is it going to be taken out on my kid on the ball court? Is it going to be taken out on my kid on the field or at school or with these grades or with their job? Are they going to lose their job? Or, you know, because retaliation is a really big thing. It's a serious thing. Several people have told me that they felt like they were being followed, that they kept seeing like the same vehicle several days in a row, you know, just places where they shouldn't be, driving past their house, pulling in their driveway. I had a guy send me a video of a woman following him, and he pulled down 119. It's a highway. It's a 2-lane highway, 1 lane on each side, you know, but it's a highway, 119. And you see him pull off onto one of these roads, and he kind of turned and backed in to where, and he turned his phone on. So as he's sitting in his driver's seat he's looking at the highway running in front of him. And this woman who had been following him pulls up in front of him and stops right in the middle of the highway, honey, right in front of 119. And she just stops and sits in front of him and stares at him. And he's got his phone up. I've seen it. I've got it. And she pulls in next to him. She eventually pulls in next to him and starts yelling at him that he's under investigation. And he better watch himself because they're watching him. And she pulls out, like, it was the craziest thing I've ever seen. That would terrify me if somebody did that, you know. And he had her tags, he had her, you know, her picture. She wasn't scared one bit. You could tell she wasn't from around here. And it makes you wonder, where are they going to hire these people, and who are the ones that are hiring them? Why are random people that are not from this area following citizens of this county? I don't know, but it's kind of scary. Anyway, all right. Motion to dismiss the indictment. All right, comes now the defendant, Sean Mickey Stines, by and through the undersigned counsel, pursuant to the 5th and 14th Amendments to the United States Constitution and Section 11 of the Kentucky Constitution and Commonwealth v. Baker, and hereby respectfully moves this court to dismiss the indictment in this case. Specifically, defendant believes that dismissal is mandatory under RC, and gives some numbers there. Given the intentional failure of the Commonwealth, the intentional, listen to these words because they matter. The intentional failure of the Commonwealth to record proceedings in front of the Letcher County Grand Jury. Additionally, the grand jury was deprived of information known to the Commonwealth, sought in questions by grand jurors, but not disclosed. Do you know what that means? That means that the grand jurors were asking the Commonwealth certain questions that the Commonwealth had the answers to, but refused to answer. Or they said they didn't know. I don't know. It doesn't really give the exact detail of what the Commonwealth's response to the questions was. It just says, sought in questions by grand jurors, but not disclosed. Doesn't really say how it wasn't disclosed, but it wasn't. Okay. Number 1, facts. Subparagraph A. On November 21st, 2024, Kentucky State Police Detective Clayton Stamper, now that was the guy who testified, there we go. All right. Yeah, I know. Sorry, y'all. I got to tell my young'un to get off his Xbox and the computer. Okay. Okay. Sorry, y'all. I don't know what else to do. Okay. On November 21st, 2024, Kentucky State Police Detective Clayton Stamper testified before the grand jury seeking a murder indictment against Sean Mickey Stines. So that detective testified in front of the grand jury as well, not just in that hearing. He also testified at the grand jury. B, there was a prior meeting between the Commonwealth and the Letcher County grand jury regarding Mr. Stines that was not recorded. At the recorded meeting, grand jurors sought information as to the relation between the case sub judice, I guess that would be the criminal and the civil, and the companion federal civil case, but were deprived of that information. Testimony in response to questions asked by the grand jurors was frequently redirected to deprive the grand jury of its independent investigation. Holy crap. Hola. The Letcher County grand jury returned an indictment charging 1 count of murder. Now, number 2, law. Subparagraph A. There was a meeting between the Commonwealth and the grand jury that was not recorded. Rule RCR 5.16 provides transcript of testimony. Okay, number 1. The attorney for the Commonwealth shall cause all of the testimony before a grand jury to be recorded. So it's the attorney for the Commonwealth, according to this, that is responsible for the testimony before grand jury to be recorded. Okay, that answers that question. For this purpose, the attorney for the Commonwealth may appoint a stenographer to take in shorthand the testimony of witnesses, or may cause the testimony to be taken by a recording device, but the record so made shall include the testimony of all witnesses. The shorthand notes or the recordings and transcript of the same, if any, shall be delivered to the retained by the attorney for the Commonwealth. Failure to have a record made, if required by paragraph 1 of this rule 516, shall be grounds for dismissal of the indictment unless the Commonwealth can show good cause for the failure. Mechanical failure of the recording device shall constitute good cause. Number 3. The stenographer or operator of the recording device and any typist who transcribes the stenographer's notes or recordings shall be sworn by the court not to disclose any testimony or the names of any witnesses except to the attorney for the Commonwealth or when testifying in court, and except that any person indicted by the grand jury shall have a right to procure a transcript of any stenographic report or a duplicate of any mechanical recording relating to his or her indictment or any part thereof upon payment of its reasonable cost. Now, whenever they get their discovery, whenever that discovery time happens, that is that window that's open, window of time that's open for the prosecutor to turn over all of their evidence. They have to turn over every bit of evidence against their client to the defense attorney and their client, the defendant. Now, a lot of times prosecutions get in trouble because I think it's called like Brady material or something like that. I'm no lawyer, so remember, I'm not trained in all of this kind of stuff, but it's called something, I forget, but it's evidence, any kind of evidence that would be in the defendant's favor, anything that would be in the defendant's favor. The prosecution has to turn that over. They have to turn it over. I'm not sure. Exculpatory. Thank you, Snail Trail. I was hoping you'd pop in there with what I was looking for. Exculpatory evidence. Thank you, sister. Thank you. Or mister. Sister or mister. Anyway, so exculpatory evidence. They have to turn that over to the defense. And if they don't do that, they get in trouble. They can get in big trouble. But this is a different situation, kind of. But all right. In the recorded session of the grand jury provided to the defendant, a grand juror references a prior meeting with the Commonwealth. Now, this is where I have a question. So does this mean, here's my question, does this mean that Jeremy Bartley or Carrie Bartley or whoever was going over these documents and reading this stuff, did they just happen across reading this where this grand juror references this prior meeting? Because I would hate, I don't think that they have like told the defense, hey, we had this other meeting and we didn't record it. I doubt that's what's happened. I think, and I could be wrong, I'm just guessing, but the way that I read this, it makes me feel like the defense, Mickey's defense, was like poring over this evidence, poring over all this discovery, and they start reading this grand jury stuff, and they see it. It sounds to me like they see in the transcript where this grand juror references this other meeting. So that means they were paying attention. And that means they're paying attention when they're going through the discovery, which is most important. How many defense attorneys from the, the free ones that you get, public defenders, how many of them probably don't even open and read some of this stuff? I mean, I've seen some really horrendous representations over time where I mean, I don't know what they did, but I don't know how they graduated law school. I'll tell you that. They were either so incompetent or they were on the take. I mean, you can't have it both ways. Oh, well, I guess you can. I guess you really can. But, okay. So in the recorded session of the grand jury provided to the defendant, so this would be, the way that I read this is going to be the discovery that was sent over to the defense. A grand juror references a prior meeting with the Commonwealth. Defendant requested from the Attorney General's office a copy of the prior meeting. The Commonwealth responded that the prior meeting was attended by the Commonwealth, but that it was only for the purpose of obtaining grand jury subpoenas for the case. And there was no testimony. So I guess old Jackie Steele didn't think that he needed to record it if there wasn't any testimony being given. First, the Commonwealth may seek subpoenas to a grand jury hearing without necessity of the grand jury intervening. Let's read that again. The Commonwealth may seek subpoenas to a grand jury hearing without necessity of the grand jury intervening. Okay, so he can seek these subpoenas without having the grand jury meet, is what I'm reading. Thus, it is curious what would necessitate the involvement of this independent body. So what Bartley's saying there is, wait a minute, you can do that without convening the grand jury. You can have those subpoenas done without making the grand jury sit for a meeting. So Bartley's a smart cookie. I've always thought he was. Thus, it is curious what would necessitate the involvement of this independent body. Second, if a subpoena was sought from the grand jury, then information must have been presented to the jurors. While the Commonwealth may classify that information as something other than testimony, it clearly related to the nature of the investigation. Regardless of how it is labeled or whether it was sworn or unsworn, the information provided to the grand jury constitutes testimony and should have been recorded. Period. You would think, this being such an important case and this being such a high profile case, like, you've not heard of this happening in any other state in the country. This is a very, very big case. Like, attention, media, eyeballs are on it everywhere. You would think that they would be dotting their I's, crossing their T's, making sure that they had everything on point. Troy says, I still think Stamper lied under oath. Bartley caught him in several. He looked very uncomfortable. And one of the things that I learned just over this whole process and them releasing the videos and stuff from that day was that Stamper is not from here, or he's not from Letcher County. I don't know if he's from any other area, surrounding area, but he's not from Letcher County, and he's not close to Mickey and the sheriff's department and them the same way that the other state cops that were there were close to Mickey. They had known him since they were 14 years old. So, all right, let's get back to this. There was no mechanical failure. The Commonwealth chose to not record its meeting with the grand jury. So there was no good reason. They just chose. All right, there it is. I'm sorry, y'all. I hate when it's doing that. I know. It just freezes for a second and then it comes back on. I don't know. They're doing maintenance, though. This kid's turned on that dang Xbox. No, they're sitting on both sides of me, messing with me. All right. So basically what they're saying is there's no mechanical failure. There was no good reason that you did not record that meeting. The reason it was not recorded is just because you chose not to. Big mess up, man. Like, who would do that? He's from the Attorney General's office. Like, he's one of the top law dogs in this state. And Jeremy and Carrie Bartley, I don't think murder cases are like their cream of the crop. You know what I mean? Like, I don't think they have a whole lot of these going on. I don't think they have a whole lot of experience. Oh, thank you, honey. Thank you. But I don't think that they have a whole lot of experience with murder cases. I mean, this is just my own thoughts on it, but they're knocking this out of the park. They really are. And that doesn't have any, and I say that not having any, I'm not for or against Mickey. I'm not for or against the judge. I don't really have any dog in those fights at all. I just want the truth. I just want to know the truth. That's it. Like so many of us, we want to know the truth. We want justice for our community. We want justice for the victims that have been absolutely dragged through the mud for years and years and years. We want transparency. Simple. Transparency. Okay. B, subsection B. The grand jury was denied information sought. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. The Commonwealth's attorney does not control the grand jury. Rather, the Commonwealth's attorney is the person with primary responsibility for presenting evidence to the grand jury concerning alleged criminal violations. However, the grand jurors may choose to hear more evidence than that which suffices to convince them that an indictment is warranted, and may exclude the Commonwealth's attorney while they question witnesses themselves. The Commonwealth's attorney may not be present while the grand jury is deliberating or voting on an indictment. And though the Commonwealth's attorney is required to draft indictments upon request of the grand jury, the Commonwealth's attorney does not sign the indictment, and the indictments are returned not to the Commonwealth's attorney, but to the court. Nothing in our Constitution, statutes, or rules classifies the grand jury as an arm of the Commonwealth's attorney. Now, this reminds me of something that's also written into a whole lot of independent contracting contracts. If you're a 1099 employee and you work for these nonprofit groups, a lot of times you are hired on as an independent contractor. Now, several years ago, this was not so, it wasn't as common as it is now. Used to, everybody that tried to get a job wanted a W-2 job. Those were jobs where they took your taxes out, right? Well, 1099 independent contractors have to take their own taxes out of their pay. And in a lot of those contracts, it's been in every one I've ever seen, it states something very similar, a sentence very, very similar to this. Nothing in our Constitution, statutes, or rules classifies the grand jury as an arm of the Commonwealth's attorney. In the nonprofit, the 1099 independent contracts that I've seen, it usually says something to the effect of nothing in in this contract or any kind of anything shall be considered employee and employer relationship, because that is not what a independent contracting job usually is. Absolutely nothing shall be referred to or perceived as an employer and employee relationship. But if you don't know what that means when you sign that contract, a lot of times, you guys are going to have to get out of here. You're distracting me and I can't keep track of what I'm thinking about. A lot of times, if you don't understand what those words mean, when you sign that, well, you put it in your pocket, file it in a drawer, and then the person who you just signed on the dotted line with, could come to you and say, I want you to go out. Now, this is part of your duties. You need to do this, and you need to do this, and you need to do this. But if you didn't read that contract right, it might say in that contract that you are specifically not to do this, this, and this. But if you don't know what you just signed, if you didn't read it, they can tell you anything's your job, and you're going to go do it when it states perfectly clear in there that you're not to do it. I see that happen a whole lot. A whole lot. I've been subject to those kinds of things before. And those very same people who gave me that contract, who said nothing shall be considered employer-employee relationship, those same board members, same people, stood in my face, looked me right dead in the eye, and said, you work for us. You are my employee. No, I ain't. So you got to be careful. And even a lawyer will know exactly what that stuff means. And they'll still, if they think that you don't know, if they think they can intimidate you just because they've got an attorney at law behind their name, they can scare you and tell you anything. And if you don't know any better, what if Bartley hadn't have caught this? Nobody had ever known it. If Bartley or whoever it was that happened to catch this, and I have a feeling that they only caught it when they read it. So that means they had to actually be reading the discovery, which I don't think a lot of lawyers do. And I think they are. I think they're reading them really good. All right. The grand jury is an investigative body acting independently of either prosecuting attorney or the judge. The hallmark of the grand jury is its independence from outside influence. It serves the invaluable function in our society of standing between the accuser and the accused, whether the latter be an individual, minority group, or other, to determine whether a charge is founded upon reason or was dictated by an intimidating power or by malice and personal ill will. So what that means is it's trying to say that the grand jury is an independent body, totally independent of the prosecutor, totally independent of the judge. They can work as their own thing. And I like what it says here, because this is actually the way that it's supposed to be. I mean, this is what they set it up to be. How many of us have heard they can indict a ham sandwich if they want to? Because why? When a grand jury meeting takes place, the defense attorney ain't there. The defendant ain't there. There ain't no defense, period, in a grand jury testimony or grand jury meeting. The prosecution will go, and they will present all their evidence. And the grand jury usually does whatever the prosecutor asks them to do. Now, we also see cases where sometimes a defense attorney is allowed to go in and present. Witnesses will come in and testify in front of a grand jury. Let's see, Miss Lynn says the indictment can be reissued when any defects in the first indictment are corrected and remedied. I think he's asking for this with prejudice or without prejudice. One of them means they can refile again. They can bring charges again. And the other one means they can't. It would be double jeopardy. Okay. Let me get back over here. The hallmark of the grand jury is its independence from outside influence. It serves I already read that part. Okay. An indictment returned by a legally constituted and unbiased grand jury, which I'm cynical. I can't help it. I've done seen too much corruption. I don't think any system where it's all honor system and there's no oversight, I don't think that you can trust that. There's just not enough trustworthy people in this world, you know. There just ain't. If valid on its face, is enough to call for trial of the charge on the merits. However, dismissal of an indictment by a trial court is appropriate if it is established that a violation substantially influenced the grand jury's decision to indict, or if there is grave doubt that the decision to indict was free from the substantial influence of such violations. I feel sure they used the video in the grand jury. You know, I feel sure that they did. Let me see. Probably would be dismissed without prejudice. This is a big case. I mean, we've heard of cases being dismissed on technicalities. There's just no way. I don't see how in the world any judge would let this be, or they're the one that would have to dismiss it, but I don't see them, granting that motion for dismissal, even if the statute says that that's what they should do. I just don't see how they could do it. I do not see where we've got him on video doing what he did. I just don't see how they could dismiss this case. I just don't. Look here, Troy. I think Bartley has been telling people what people want to hear to throw the prosecution off. And when trial comes, tell all. Could be. Could be. I think they've got a definite strategy. And I think that they're doing good so far. I mean, ain't really much happened yet, but I don't know. I'm impressed. I'm impressed with him and his wife both. I just love his little wife, how she looks. She just looks like a powerhouse, babe. I like how she'll sit there with a stone face. Like she's a real bad ass. Sorry. All right. An indictment. Okay. Make sure I didn't read that already. A court may dismiss an indictment where a prosecutor knowingly or intentionally presents misleading testimony to the grand jury that results in actual prejudice to the defendant. In Commonwealth v. Baker, a detective testified at grand jury proceedings that the defendant struck her children with an aluminum baseball bat, while in reality the allegation was that a stick was used for the same purposes. After holding an evidentiary hearing, the trial court dismissed the indictment with prejudice, noting the legal obligation of prosecutors to observe the independent status of the grand jury. The court found that the detective's testimony was material and affected the grand jury's decision to indict. The court also found that the Commonwealth's attorney had knowingly or recklessly elicited the incorrect testimony, and that the detective voluntarily testified even though he had no personal knowledge of the facts of the case. On appeal, the Court of Appeals concurred that this deprived the grand jury of its ability to exercise its independent judgment. In the case at bar, the Commonwealth elicited and Detective Clayton Stamper testified to multiple misleading statements before the Letcher County grand jury. This testimony prejudiced Mr. Stines and resulted in an indictment of murder. The case was presented to the grand jury approximately 2 months after the defendant's arrest and preliminary hearing. The detective and the Attorney General's office had ample opportunity to investigate and review evidence, including witness statements before presentation to the grand jury. Further, the Attorney General's office conducted the investigation into Detective Ben Fields. This investigation, the resulting charges, and companion civil case are central to the facts of the case sub judice. Holy cow. So you know what they're saying? That Ben's case is directly related to this one. That's pretty much what I heard. Is that what y'all heard? That's what I heard. Let me read it again. Further, the Attorney General's office conducted the investigation into Detective Ben Fields. That was the Attorney General's office, Matt Easter, that we listened to in all of those recordings of Sabrina. All of Ben's victims. We heard Ben himself on his own interview. And it's the same Attorney General's office that's prosecuting Mickey, that prosecuted Ben. I don't know why I never thought of that before. Same investigators. Same investigators that are in the Attorney General's office investigating Mickey's case as it is. If they're the ones that are doing it, I mean, I know it says that the state police is investigating Detective Stamper, but they have to be working with the Attorney General's office. Has to be. Howard, Elizabeth, you got the shiny look. Woohoo! That's from the new camera, ain't it? Y'all, I need some help paying for this new equipment. So anybody that wants to help us pay for this new equipment, I could really use it. All right. Hit the like button if nothing else. That helps a great deal. Look there. Steel man seeking Matt Easter, who treated Sabrina like a whore, not a victim. Man, you hit that right on the head, honey. Okay, let me get back over here to read this. This investigation, the resulting charges, and companion civil case are central to the facts of this case. Unlike the testifying officer in Baker, Detective Stamper is the lead investigator in this case. This case is even more explicit than Baker because the court does not have to infer excuse me, what facts were important to the grand jury. This case is even more explicit than Baker because the court does not have to infer what facts were important to the grand jury. The grand jurors asked questions and were prevented from hearing complete answers. Had the Commonwealth presented complete and accurate testimony to the grand jury, the decision to charge, or at least the choice of appropriate charge, would likely have been different. That's what I was getting ready to say. Coming to the end of that paragraph, it really sounds like, you know, if you think back to when they had that first hearing, Bartley asked for them to deny the how'd that go, you guys? He asked for a charge, a lesser charge. I forget what it was. Maybe manslaughter or something like that. But he was asking for it not to go on, be waived. I'm not really sure. I'm not sure how that rolls out. The grand jurors asked questions and were prevented from hearing complete answers. Had the Commonwealth presented complete and accurate testimony to the grand jury, the decision to charge, or at least the choice of appropriate charge, would likely have been different. Approximately 12 of the 25 minutes of the hearing was consumed by grand juror questions. It is evident that despite seeing a portion of the video evidence, the grand jury sought additional information to make their decision whether to indict and upon what charge. Let me read that again. It is evident that despite seeing a portion of the video evidence, the grand jury sought additional information to make their decision whether to indict and upon what charge. So I think what he's saying there is that the grand jury really took time and was trying to ask. It says they sought additional information on which to make their decision whether to indict and upon what charge. Despite the grand jury's specific inquiry, known information as to allegations made during the civil case were withheld. Known information as to allegations made during the civil case were withheld. So I think he's saying that Jackie Steele was not answering the jurors' questions. So he was not giving them the information about the civil case and the accusations that were made in that civil case. That's what it sounds to me like they're saying. The grand jury also sought mental health information that was not disclosed, and the officer was permitted to testify that defendant was in his sane mind at the time of the alleged shooting. The detective was also permitted, in contravention of the Fifth Amendment, to comment multiple times on defendant's failure to speak with law enforcement. Okay, let me read that again. The detective was also permitted, in contravention of the Fifth Amendment, to comment multiple times on defendant's failure to speak with law enforcement. Oh, they're saying the court permitted the officer to talk about Mickey not talking with the detectives. If you think back to those videos that we saw, well, number one, they never read him his rights. Nobody ever read Mickey his Miranda rights. And they asked him from the time he was in the hallway for the hour trip to Leslie County to the jail. They continued to ask him. They continued to ask him. He never did give any answer. He never responded with anything that was like guilt. Like he didn't admit to it. He didn't say anything. They asked him several times. Does this have anything to do with your family? Does this have anything to do with your family, Mickey? They asked him what? Who knows how many times they asked him. But it seems like that's all that they were saying. And he absolutely was not saying a word. He wasn't saying nothing. He didn't give any information why he did it. And another thing, too, Clayton Stamper gets up on the stand at the hearing, that first initial hearing, and he says that Mickey said after he was arrested, or when he was surrendering, that Mickey said they were trying to kidnap my wife and kid. Now, he says that we rewatched the hearing recently, and he says that Mickey had said that to whoever the officers, the first responders, the first people who got to him, and he surrendered. Mickey had said it to them, and then they told Stamper that that's what he said. We don't hear him say that, though. In the hallway video, we see Mickey say he was really only concerned about himself. He wasn't saying that they were after his wife and kid. We never hear that one time. Not one time in any of the video that's been released so far. We never hear that. We don't hear him mention his wife. We don't hear him mention his kid. Nothing. He says, I've got 5 grandkids, to the state cop out in the hallway. But he doesn't say anything about anybody hurting those kids. He doesn't say anything about nobody kidnapping those kids. He only says about himself. He never says it about his wife and his kids. So I'm kind of confused why Clayton Stamper would even report that at that hearing, because he didn't report much. He did not disclose much information at all. And so, and they didn't really do much because the bar was so low for that hearing. So they didn't need to put on their whole case to get it waived upstairs. That video was all they needed. Yeah, he's got 5 grandbabies, I reckon. I didn't know it, but he does. Okay. And so the detective was also permitted, in contravention of the Fifth Amendment, to comment multiple times on defendant's failure to speak with law enforcement. And I'm guessing the way that he wrote that in this motion, it must not be permitted. Like, they must not be able to talk about that. That's how I'm taking it. I don't know. They don't have to read anybody their rights when they're arresting them. They only have to read somebody their Miranda rights if they're going to question them, for their statements to be used against them in a court of law. People get that really confused all the time. They think if somebody's arrested them and put handcuffs on them and are taking them to jail, they didn't read me my rights. They don't have to read you your rights to arrest you. The only time they have to read you your rights is if they are going to question you about a crime. They were questioning him all the way to the jail, but nobody read him his rights. He does, Miss Crystal. He has a son, I reckon. Mickey has a son. I don't know if it's a step or if it's a biological, I don't know, but he does have a son, and the son has 5 kids. I've seen their pictures and stuff. I just didn't know that. And he's in the courtroom a lot. Every time Mickey's in court, that boy's in there with his mom and sister. So he does have a son, and the son's got 5 kids. So yep. I didn't know it either, but he does. Okay. The defendant respectfully requests an evidentiary hearing to present specific testimony and evidence relevant to the foregoing matters, and asserts that such evidence will establish that the Letcher County Grand Jury was deprived of material information. This deprivation, the defendant contends, warrants dismissal of the indictment. Wherefore, the defendant respectfully requests that this honorable court, number 1, grant an evidentiary hearing to allow the presentation of testimony and evidence relevant to the issues set forth herein. Number 2, find that the Letcher County Grand Jury was deprived of material information necessary to its deliberations. Conclude that such deprivation undermined the integrity of the grand jury process. And number 4, dismiss the indictment with prejudice, or grant such other and further relief as this court deems just and proper. Respectfully submitted, Jeremy Bartley, Carrie Bartley, and James Cox. So James Cox must be, I didn't know that there was another lawyer on Mickey's defense. So this Cox guy, it says he's from Mount Sterling. Is that where I see that? No, not Mount Sterling. I'm sorry, Mount Vernon. So he's from Mount Vernon, Kentucky. The Bartleys are from Somerset. But James Cox is the law office of James L. Cox, PSC, Mount Vernon, Kentucky. And then it just has the certificate of service and all that at the end. This motion was served via electronic service on this day, the 4th day of June. Special Prosecutions Division, Deputy Director Ramsey Dahlem, and Jackie Steele, Kentucky Office of the Attorney General. I'm telling you, let's get, all right, let's look at these. Supers, thank you, everybody. Thank you. So much corruption. Bless you. Tammy C. Bless you, Tammy C. Thank you for all you are doing to keep us updated on the Stines case. Love your hair too. Thanks. Thanks. Leslie Maggard. Bless you, honey. Thank you. Stephanie Hollis. Thank you, thank you, thank you. Michelle Maynard Koenig. Bless you. Thank you, thank you, thank you. Gregory C. Lynn Foley. Thank you for your super sticker. Connie W. Thank you for your super sticker. I cannot tell you how much I need it. Thank you. Bless you, bless you, bless you. All right, guys. So let's go back at some of your comments. We had a huge audience tonight, so we're not going to be able to Okay, sorry guys. I don't know what. Anyway, Cindy RN, but you haven't seen all timestamp video. I promise you that. There's still a piece of video that we've not seen yet. There is still the piece of video from where he surrendered. Sheesh, y'all. I'm sorry. I hate that that happens. I don't know why. I don't know what else to do. Yes, I have Intermountain cable, but I'm not on Wi-Fi. I'm plugged straight in, and I've got the highest internet package that you can get. So I don't know. We'll just try to suffer through it, guys. I hate that we lose people when that happens, but still, man, you do not have to be read your rights until questioned. That's exactly right. Terry, Grand jury may have asked about the camera in judges' chambers, and prosecution did not want to answer why or who installed it. Can of worms. Yeah, that, see, is a prosecutor allowed to do that? Are they allowed to, not answer? I don't know. I don't think that they're allowed to do that, are they? Like, we're only going to tell you what we want you to know, but we don't want you to ask any other questions. And so if they, and what Bartley specifically said in that motion is that the jurors asked the questions, but the prosecutor redirected them. We see that a lot. We're trial watchers on this show, or on this channel, y'all. During the day, if you're not a regular, during the day we watch trials, and in the evenings we have our regular show. And in a lot of trials, you know, we see that. We see how a lawyer, regardless of what side, will try to redirect with their questions. Why not did the feds come in as of yet? Your guess is as good as mine. Your guess is as good as mine. Let's see. Boomer 1964. Set your router to give your computer priority. Thank you. I'll figure that out. Chat GPT, guys, is your best friend. If you can't figure out how to do something, my little Chat GPT guy showed me right how to set up all of my merch shop, my entire shop. I couldn't figure it out. I was paying for it for 4 months and still didn't have it launched. Sat down with Chat GPT and had it launched in one day. It told me everything to do. I bet he was Mirandized, or that would be one of the first motions waived. But then again, if he were legally insane at the time of the crime, he wasn't in his legal mind to waive his right. Well, I remember in one of them, it was in something that we either read or we listened to. They talked, it was something, they talked about his rights. And that said, and if I remember correctly, which I could be remembering it wrong, but I for some reason I'm wanting to say that I remember seeing something about his rights in something, or hearing it somewhere, and it said that they had not read him his rights. They asked him if anybody had read him his rights there at the courthouse, and I'm wanting to say that they said no, that he had not been read his rights. If he had been read, because they didn't question him, is what they were saying. He was never formally interviewed. That matters. So they're saying nobody ever went to the jail, sat down with him and said, all right, Mickey, you know, we got to sit down and talk to you. We're going to read you your rights first. Like, you know, you watch a lot. If you're like me, you watch a lot of interrogations. I do. I watch a ton of them. And anytime they come in a formal interview, it's recorded, video recorded. Oftentimes they'll take their body cams off and sit their body cams on the table to record. They'll have recorders in the interrogation rooms that record. Now, used to, you'd see them pull out a little tape recorder. Sometimes you'll still see that. They'll pull out a little tape recorder and they'll audio tape it as well. If they're at somebody's home and they're questioning somebody at their house or, outside of the department, a lot of times they'll do it on their body cam. And sometimes you even see them pull out that audio recorder so they get it double recorded. But I could be wrong about that, but I feel like I remember that somewhere. Because somebody had asked them if he had been formally interviewed, and they said no. He had not been. And I remember being like, why? Why would they not go and interview him? That just blows my mind. See you later says the law does require you to provide your name if a police officer asks for it, but you can generally choose to be silent for any other questions the police may ask. Penn v. Mims. Yeah. So if they are if they're doing any kind of investigation, which I'm no lawyer or nothing, y'all, so I'm not giving any kind of advice or anything, but so many people don't understand their rights, and what they think they understand is wrong. A lot of people I've seen just throw an absolute hissy fit in the back of a police car. You didn't read me my rights. You didn't read me my rights. Oh, duh. They ain't got to. I need to call my lawyer. Honey, you don't call your lawyer on the side of the road. You don't call you don't get your one phone call while you're sitting in the driver's seat. Oh gosh, the faces that it freezes on me. The faces. I think that's a conspiracy. It finds the worst facial expressions I can make. Freeze. Regina K. In my experience, when things are quiet, yet everyone knows, it means they all need to get their ducks in a row and get their stories straight. Well, I saw somebody down in town a couple days ago, and we were just chatting, and they said, I hear the prosecutor's losing it. And I was like, huh? And I thought, yeah, I'm sure the stress and the pressure is making him lose his cool. I've heard they've been pounding on desks, acting like a 3-year-old, throwing big, screaming, yelling, temper tantrums, threatening to fire everybody in the office, threatening to fire people's relatives. I mean, I reckon this butthead really has acted foolish so far. And I was like, well, that don't surprise me. And they said no, like really losing it. And I was like, huh? And they said, like Mickey losing it. And I was like, what? And they said that just acting so paranoid, acting like everybody's out to get him. Several people have told me that the office down there is not even like open. Like you can't just walk into the prosecutor's office anymore. You can, you have to like call and make an appointment. Like you can't just go and open the door and walk in anymore. Which, like, and I remember right after the shooting, you had him come on Facebook and did a video, and he said that he didn't feel safe in the prosecutor's office. So I don't know what all they've done down there. I don't know if they've well, I guess they've just locked the doors. I guess they've just locked the doors. So, who knows? Who knows? I think that when people act like that, they've got a guilty conscience. I think Mickey had a guilty conscience. I think Mickey knew so much, and it wasn't just about everybody else. I just don't believe that you can be in that circle, even if you're the odd man out. I just don't believe that you can be in that circle for 20 years in different roles. You worked with those same exact people. You were a bailiff for Mullins, talking about Mickey. You were Mullins's bailiff for the 10 years that Ben Fields was working in the jail underneath you. And they were bringing people up and down that staircase from the jail upstairs to district court every single day. And how many defendants came up and down? So you worked right beside Ben all those years, and you never saw Ben doing anything bad. You worked hand in hand with these people. The preacher man was your best friend. As soon as this shooting happened, he hightailed it back to his family. Why? Why would you feel like that was your place to take off from the courthouse and run all the way across the county to Mickey's family? And I'm their pastor. He portrayed himself that he was Kevin Mullins' pastor and he was Mickey Stines' pastor. Well, let me tell you a little thing about churches in this area. If you go to a Church of Christ, that is a completely separate denomination from like an undenominational church, and they're very, very strict. Their rules and just the morals and the values that they live by, it's not like somebody who goes to a Church of Christ is not, I just don't see turning around and then going underneath an undenominated church, undenominated, I guess is the word, and then just take on somebody as your pastor. Like, that's a very sacred thing. That's a very sacred role. You just don't let anybody be your pastor. A preacher is a different thing. You can go sit underneath the same preacher for 10 years. You can go sit under the same preacher for 10 years and that be your preacher, but it not be your pastor. That's just a very delicate topic there. But that struck me as odd that the preacher would come out and say, I was Kevin's pastor. I was Mickey's pastor. And the stuff that we know, that was going on, stuff that I've already got evidence about, stuff I've already seen. It. I mean, I don't need any, I don't need any. I've already seen it. So I know some of what was going on down there. And there's just no way that Mickey didn't. You just can't be that close to people and not know what's going on. You just can't. I don't buy it anyway. I don't buy it for a second. I just think they all got caught. Where did the preacher attend school? He's from Cumberland. I'm also from Cumberland. So I know who the preacher is. I know all about him. Snail trail, honey, you got that right. If you keep speaking after arrest and the cops don't Mirandize you, then shame on you. All that is admissible because you just keep talking. Thank you, Snail Trail. Absolutely. Cops don't have to Mirandize if the case doesn't need questions. Awesome. Awesome explanation. Thank you, thank you, thank you. And people get really bent out of shape about this kind of stuff. Like they really think, I want my lawyer. I want to call my lawyer. Fight to the death over all this stuff, and they're wrong. Police are not required to read your Miranda rights before or during an arrest. No, 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 no. But if they would have went in for a formal interview with Mickey, they would have went to Leslie County Jail and sat down with him in a room and said, Mickey, we want to talk to you. We're here to interview you, but we got to read you your rights first. And something that they do a lot, they'll kind of trick you. They're like, oh, we can't, I got to read you these rights. I got to make sure you understand your rights. Okay. I got to make sure. And they act like they're your best buddy. Let me make sure you understand every word of this. I'm going to help you. I'm going to read this for you, and I'm going to hold your hand, and I'm going to make sure that you understand every single word that I say. And then they read them all, and then they want you to just sign. Just sign it. Just sign it. Yeah, just sign it. If you don't say, I want an attorney, then they're going to just kind of push them rights. All they want is your signature on the bottom of that paper. That's all they want. And once they get that signature on the bottom of that paper, then you're all theirs. Unless you do what's right. It doesn't matter if you're guilty or not. It doesn't matter. Ask for a lawyer. For the love of God, ask for an attorney. Don't tell on yourself. I mean, you know, I hate to say that, but don't tell on yourself, man. Because nothing that they say, oh, it's going to make you feel better. Oh, it's going to get all that off your shoulders. It'll feel like a weight's lifted up off your chest. Well, maybe, but confess it to God. Don't confess it to them. Listen, so there was a boy from Cumberland, and he was really bad into the rug scene. He was one of the preacher's best rug buddies. They all ran in that circle of boys. Some of them were former ball players. The preacher man himself played for the CEO and president of Unite. He played, there was several of them in that circle that played ball in school. But a lot of them, we see it a lot. Spoiled through school, patted on the back, put up on pedestals, given anything they want, was never told no, and then became what they just became, once they got turned into an adult. The preacher had like 6 or 7 trafficking convictions on his criminal record that former Governor Bevin gave him a complete and full pardon for. And all the connections involved in that. The governor, the attorney general, being ARC's founder's college buddy. You've got people down there in that courthouse that was doing the exact same thing as Ben Fields. The exact same thing. Only they didn't have arrest powers. But you know what's funny? Neither did Ben Fields. Ben didn't have arrest powers outside of the courtroom. He was a court security officer. He was not a policeman. He did not have arresting powers to be arresting somebody at their home. But yet, how many people did he go out to their house? How many of these girls, these women, did he go out to their house, put them in his car, and take them back to the jail to arrest them? Well, he didn't put handcuffs on them. He just told them to get in his vehicle, and he took them to the jail and booked them in the jail. That ain't no different. Just because he didn't put a pair of handcuffs on them, they didn't think. You can't tell me those women thought they had an option. If Ben said, come on, you're going back to jail. If they would have said, no, I ain't going nowhere with you, they would have gotten in more trouble. They would have just gotten more trouble. He was setting them escape warrants on these women who turned him down. They had no choice. They had no options. It was, I need to do what's best for me. I need to do what's going to keep me out of jail. I can tell you, I sure don't want to be sitting down there in that nasty filth place. I mean, it's disgusting down there. It always was before. I don't know why it would be any different now. They sure ain't putting no money into it. Where's all the money? Where is all this money going? You can't tell me that jail ain't had a ton of money coming through it lately, the last couple years, since they have figured out how to get all this grant money, since they figured out how to use the addictions. Before, they wouldn't help nobody. They didn't care. They'd let you lay there and die. They weren't taking you to the hospital. They weren't going to take you to see no doctor. And you sure as hell wasn't going to get no medicine. There have been a lot of deaths happen at that jail. And deaths that didn't have to happen. People that left the jail and died at the hospital. Didn't have to happen. I've had a whole lot of people reach out to me whose children were beaten down there in that jail. There's been a lot of bad stuff happen down there at that jail. And how in the heck has the jail been able to stay out of all of this? How come there's not been one jailer, not one jailer that's been mentioned in any of this stuff? You ain't got no investigations. You don't have no detectives. You don't have anybody asking any questions. Nowhere. Nowhere. And the only time that the FBI came into this area was, number one, to investigate Scott Blair, our neighboring county's prosecutor, who was committing SMEX offenses towards the defendants he was prosecuting. R-ing and S word, otomy. Both men, because his preference was men. I don't know if any women were. There was just one of his victims came forward to the newspaper and told it into the newspaper. What was I supposed to do? He'd send me back to prison. And it sounded to me like the guy was straight. And I mean, SAing somebody is bad, and it doesn't matter what gender it is. But, you know, I just kind of feel really, I don't know, that just hits me all a completely different way. Like if some prosecutor did that to my son, I have all boys. I don't have any daughters. And I prayed when I was pregnant with each one of them that I didn't have any girls. I regret that now, but God answered my prayers and gave me all boys. If a coach or anybody was to do that to my child, oh, Katie, bar the doors, y'all. Katie, bar the doors. But yet, the FBI, and guess who was his defense attorney? Ned Pillersdorf. Oh, yeah. So Ned, who's now these victims' attorneys, he knows the other side of it. He's defended the suspect. He's defended the defendant. So he's been part of those backroom negotiations when you sit down and try to come up with a plea. Well, Ned, honey, knocked it out of the park for old Blair, Scott Blair. Where's the SMEX charges? Where's any of the drug charges? He was making all these people, he was addicted to meth. He was making them bring it to him. On top of the SMEX stuff. And this is a prosecutor. And yet our FBI, who conducted this investigation, what do they agree to? Well, Ned got them to agree for a plea bargain of honest services fraud. Really? So there's no SMEX charges? There's no SMEX offender registry? Really? There's no drug charges? Really? Oh. So he gets 4.5 years in prison and just walks on everything else. Wow. Good going, FBI. Good going, feds. So I'm not real optimistic, even if the feds did come in here. And then the other investigation that the feds were involved in, ARC, Medicaid fraud. We've not heard of hiding a hair about that investigation. Not a bit. They put out a big teaser about it, asking everybody that if you had any information, let us know. Well, I know that there was a lot of people filled out that form. There was a lot of people filled out that form. Nothing's happened. We've not heard nothing. And I very seriously doubt we will. They have closed down almost all of their so here, Melissa Hoople. None of this stuff surprises people in Scioto County, Ohio. Scapegoat Michael Mirren, a Portsmouth, Ohio attorney, was indicted on felony charges related to human trafficking. Deeper for sure. I think this is all human trafficking right here. I think whenever all that money started coming in and they figured out how all they had to do was fill rehab beds, it became a human trafficking ring. We had sex trafficking that I feel was happening before all the rehab money got everybody excited. And I think it was just for personal gain. It was just for personal pleasure. I don't think that it was really, I don't personally think that it was a big money maker, but I could be wrong. Maybe it was. Heck, I don't know. But I think it was mainly for a bunch of perverted old men. And they have set this in place decades ago. I don't think that the same ones now, were the same ones 30 years ago. I think it has just spread. The game is the same. The only thing that changes are the players. And when you don't have people that are properly trained and educated, whenever they come on to the agency, the department, whatever, they're being trained by their superiors. So they're being trained by the very people who have set all of these systems into place. So now you have a whole bunch of law dogs with little training, but what training and experience they do have is with each other. And they just transfer and change and rotate from one department to the next. Investigations, forget it. Forget it. Do you know how many murders have happened in Letcher County? And you got people that don't even want to get up off their tail and walk outside of the city hall when they're chief of police. They sit there and pick on their nails. Me and the city manager's got lunch coming at 12. We don't want to get our shoes dirty. No, but I want you to hire my grandson. Oh, come on, buddy. Oh, your daughter needs a job too? Okay, yeah, we need you to hire his daughter too. That's what our departments are full of. Let's see.
Teammate, you suck!
RJG. I think Blair was only indicted and charged with honest services fraud. You've got to be kidding. If he was only indicted and charged with that, what does that mean? So who presented all the evidence to the grand jury on his case? I wonder who the prosecutor was on that. Did they give all the grand jury all of that information as well? That's very fascinating. Very interesting. Reagan Green says they're still working on ARC. I hope so. One thing about the feds is that they take their sweet time. When they finally do come knocking on the door, they've done got you. And they've got you 10 different ways. Cindy RN, the head of our mental health and substance abuse director for the state of Oklahoma, was just fired for losing like $4.5 million. They don't know where it went. Well, at least they had some form of consequence. I mean, you'd think that they would have to show where the money went or get indicted. I mean, is it not theft? Is it not theft? Does not somebody have to be held accountable for all this money? I don't care if it's your cousin. I don't care if it's your brother. I don't care if it's your mother. That just means that she should have known better. You know? Just means they should have known better. Denise, think back on how Preacher Man was on a mission running out of that courthouse. I can still see him on that video, honey. I think about it all the time. Right down them steps, right there. He came running down, took off running down this sidewalk and about knocked old girl over. And then he was on that video saying, thank God it could have been me. It could have been me. It sure could have. What'd you say to him before he went in there all half-cocked, buddy? I'd like to know that. The truth is stranger than fiction. Our local sheriff got less time for stealing guns confiscated and illegally not given back until he refused to give guns back to retired undercover narc. Well, I think it was our fiscal court, wasn't it? They agreed to sell every single one of the county's old service weapons, I think is what it was. I might have that part wrong. But they sold a whole bunch of weapons to one guy. And it's the one deputy that they just hired back onto the sheriff's department. And they put it in the newspaper that they were selling all of them to him. So he got them all. Like, how many was that? And it looked like it was a bunch. How much did you sell them for? One man had $50,000 just laying around. I don't know. I'd like to see the receipts on all that kind of stuff. I'd like to see the paperwork on all that kind of stuff. But what I see a lot is it looks like they just do whatever the heck they want, even in the courthouse. Even in the courthouse. They just do what they want. And if there ain't nobody to challenge them, if there ain't nobody to come up, against whatever they're doing, who knows? Whoever knows about it? Nobody ever knows about it. Just goes by the wayside. Next. Dave, finally a flattering freeze. All right, guys, we'll get off of here tonight. Pretty sweet pea. I bet his butt cheeks was squeezed as tight as all get out, scooting fast as he could. Yeah. Blair was charged with honest services wire fraud in April 2024. Alleged he used his position to assist individuals facing criminal charges in exchange for sexual favors and methamphetamine. And one of his victims came out to the newspaper and told him there we are. No striving for Titus. Mickey went to the AG and they refused to investigate wrongdoings. No, that was the state police. He called the state police, and the state police, the same state police that are investigating this murder. Yeah, same ones. He called them and said, I need you to investigate these allegations that have been made against my deputy. We've got a civil suit filed. And the state police said, no, we decline. We can't investigate that. We work too closely with you. And so nobody did until the Attorney General's office was forced to come in and do an investigation because the civil suit had been filed. There was Ned Pillersdorf's civil suit had been filed in court. Somebody had to investigate. They had too much evidence for them not to come in. But it's just very suspicious to me that the allegations were this was a whole group of people that were committing these crimes. And the only person that was investigated was Ben. Nobody else was even looked at. They didn't subpoena anybody else's phone records. The only people that they subpoenaed was Ben, and I don't know if they even subpoenaed Mickey's. I think that the discovery I got is all from Ben. I don't think they did Mickey's. I could be wrong, but I don't think so. I think it was all Ben's. So I feel like it makes me wonder, did they all come in and have a big sit down and say, okay, look, we're going to make all this go away. This is a big deal, but we're going to make it all go away. You just give us Ben. We'll give him a plea. 6 months. He can serve it in his own jail where his wife works, where he was given every comfort that he could possibly be given. There's even somebody who worked at the jail said he even left a couple times. Now, I don't know who he was supposedly left with, but I can see that happening. Absolutely. They made him a trustee. The jailer told me himself. He made him trustee the very next week. He came in, and I think it probably takes about a week to get that approved or something. And he was a trustee the very next week. Said he was trustworthy. He was dependable. He was reliable. He was a good dude, man. He was a good dude. And I take full responsibility for making him the trustee. I take full responsibility for that decision, he said to me. Well, okay. And you thought somebody who was swearing out false escape warrants on the same women that have been in your jail, That's trustworthy? You think this man that was coercing these women into what they were doing and then pimping them out to his uncle, his 80-year-old uncle, that's trustworthy? Okay. Couldn't be the fact that y'all are friends, right? Couldn't be that. Couldn't be that all you families are all friends. Could it? Couldn't be that his sister is over drug court and has been for 10 years. Couldn't be that mommy's on the board of Kane Kitchen bringing in millions and millions into here. Couldn't be. Oh no. Yes. Pastor at a church. So there is a little section of Cumberland across the mountain called Pride Terrace. And it's kind of a black community. It's a black church. And they sent out a post the other day saying that it was a well-known black church and that they were welcoming their very first white pastor. And they were bringing in Michael Clark. There was a boy who ran with Michael for many, many, many years. And I reckon it was his mom who is over that church. She's kind of a big wig in that church. And from what I was told, she pretty much gave him the gig, allegedly. But her son was one of his good friends and using buddies. So, allegedly. So now he is taking over that church. And his wife, the preacher's wife, comes from a really good family, I reckon. Very religious. And they have a big church. And I think that's where the preacher started. Was it their church? And he didn't stay. I don't know what the circumstances were under that, but he did not stay. And he just jumped from church to church to church to church to church. He was very impressive to some of these mega churches. Think about it. Think who his employers are. This is ARC people. So it's ARC money, ARC connections. So you got some big time mega churches that were very impressed with this mouthpiece that this fella has. The gift of gab. Oh, he's got it. But it's like one of them used car salesmen, you know. To some of us, we can spot it a mile away. But to others, they're like, oh, mesmerized by him. I don't know. Like the Pied Piper. But, you know, the Bible says, many will come in my name, whom I did not send. So, you know, we're going to see a lot of them, y'all. There's going to be a whole lot of them out there, and they're going to trick us, and they're going to fool us, and they're going to deceive us. Sorry, y'all. M.A. Sunshine, FYI, it's not just you having problems. All the channels I watch, from cop channels to farmers to homesteaders to cooking to crafts, are all having the same problems you are with things freezing. Thank you. Thank you so much. I won't worry about it as much as what I have been. DC 28, I get a bad taste in my mouth when ARC is mentioned. I do too. And you know something else is that judge from Pikeville, the one who they just indicted on all those theft and wire fraud and all them charges. He, before all this stuff kind of blew up on him, he was bad mouthing ARC. He was saying how ARC would, he compared them to a cartel. And I forget what else he said about them. But he was not a fan of ARC. And the next thing you know, he ends up with all these charges on him. And I saw somebody post something saying, oh, yeah, well, it would be really easy for somebody to slip in these timesheets when they were bringing in all the stuff to have him sign. What if he didn't even know that he was signing that for this person? And I was like, well, I've heard of stuff like that happening. You know, people slipping papers in with a stack of other papers and getting somebody to sign over stuff like that. But you never really think of it actually happening. You know, could that really happen? I don't know. I don't know. It'd be a pretty easy way of stealing $500,000 every year for 10 years. I don't know. We'll have to wait and see on that. But I think it is very coincidental that he was not a fan of ARC. And yet there's been an investigation. He's been indicted on federal charges. All these, and there's not been one investigation into this bunch down here. I find that very suspicious. You have all this other stuff going on everywhere else, but yet you don't have one agency in here doing anything with this bunch here. They just keep appointing them to bigger and giving them better promotions, and we just give them all the money. We just give them all everything. Oh, goodness. All right, guys. Well, I'm going to go ahead and end this one. This is a good comment. Well, T.D. Jakes was pastor at one of the largest mega churches and was going to ditty parties and having pics taken and published. I know, man. I know. That's what I'm saying. They've gotten by with this for so long. Before Mickey shot Kevin, before that happened, shoot, you had one of them down, a couple of them, not just one. You had a couple of them down there, these defense attorneys that were just, honey, they brag. They bragged so much about it. One specific lawyer lives close to, in the same neighborhood as a swimming pool. And one woman last year said she had to leave the pool. She was there just swimming, having her good, a good summertime, and said she had to get her stuff and leave because one of these defense attorneys would not leave her alone. Harassed her and harassed her and harassed her the whole time she was there, trying to get her to leave the pool and go back to his place. Oh, we just live right close. Come on. No, she left the pool. She didn't go to his house. She left the pool. And she was offended. From what I heard, she was offended that she had to leave where she was just to stop being harassed. You know, people, they just think that they're, and one of them's best quote, and I've heard it from 100 different people, favorite quote: I ain't no drug addict. I'm just a hardcore pervert. Pay. Little pig Latin there for y'all. Loved it. Loved it. That was a badge of honor for that fella until this mess happened. And now everybody acts like, how dare you mention that? Well, shoot fire. It was a badge of honor 2 years ago. Didn't care who knew it. But now, how dare we mention that now? I don't care if you mentioned it 2 years ago, but now you better not say it. Why? Who's your own favorite quote? All right, guys. Steelman says his wife has made many statements over the years that made me think she was saying he was gay and she knew it. I think I think they're talking about Scott Blair, that prosecutor. Listen, I have a hard time believing that a wife does not know who her husband really is. I just have a hard time believing that. I really do. I believe that here right now, honey. I just believe that people show who they are behind closed doors to their spouse. Anyway, all right, guys. My youngin's wanting me to get off here so he can get on his Xbox. All right. Lord, thank you, Jesus, for another night being able to come together in your name, being able to come together on this platform. Lord, we're so thankful for just the community that you've given us, Lord. So many of us have met new people and we're just having a really good time getting to know one another and supporting truth, and that's all we're wanting to know, Lord, is the truth. Anyway, we pray for the victims of all of these cases that we talk about, Lord. We pray for the suspects and the defendants in these cases and their families, that you will give them the peace and the comfort that they need to be able to move forward. We pray that you will just go with us as we go through this week. Go before us in whatever we have that we are dealing with, whether it is something physical, whether it's emotional, whether it's mental, whether it's financial. It doesn't matter. Whether it's a legal situation, Lord, that's what I want to pray for tonight specifically. So many people are looking for a lawyer. So many people have reached out to me recently, Lord, needing an attorney. Somebody that'll just take their case. Somebody that will just listen to them. Lord, we pray that you'll move. We pray that you will open the door. Close those doors that no man can open. And we pray that you open doors that no man can shut. I thank you for saving my soul, Lord. I pray that you will forgive me for my sins. And just go with me, Lord. Thank you, Jesus. Thank you for saving my soul, Lord. Thank you for just letting me feel your presence every single day. I love you, Jesus. So many of us find you on our knees, Lord. So for those who have not yet found you, I pray that you do whatever you need to do. If it means taking them to their knees, I pray that you take them to their knees. I pray that you soften the hearts of the lost and lead them to you. I pray that you go with us, and until we come back again tomorrow, we give you all praise, honor, and glory in Jesus' name, in Jesus' name. Amen, y'all. Amen. All of a sudden, you become the bad guy and not the avert pay. Steelman says. All right, guys. Well, you all have a great rest of your night, and we will see you tomorrow. Peace out, Girl Scout. Bye.